Okay, great. Welcome, everybody, to another deep dive webinar on AI transparency. Today, we'll be talking about the California AI Transparency Act. Let me start by sharing my screen, and we can get started. So, what is CAITA, or for an acronym, the California AI Transparency Act? We will be doing a deep dive on what this means for AI developers and consumers in the state of California today. Today you will learn what CAITA legislation is and where it comes from, who is affected, how CAITA wants content to be identified, how to comply with the law technically and at a reasonable price. What is CAITA? So it is a statewide legislation on AI output transparency in the state of California in the United States. It's going to become a law on January 1st, 2026, but it was clubbed through the California legislature already in 2024. It is part of a larger legislative initiative on AI laws in California, namely AB 2885. So SB 942, CAITA, there's a couple of different acronyms that they use. It's all for the California AI Transparency Act. But there are a bunch of other laws that affect AI services differently, which is all contained in AB 2885. So if you want to do a bit more of a deep dive there, you can check it out on the California Parliament website. Here you have it. The Senate Bill number 942, that I mentioned before, was approved by the governor in September 19th, 2024. But it is going to eventually be part of law on the 1st of January, 2026. So let's go into what who it's for. So it is for companies offering generative AI systems with 1 million plus monthly visitors that produce image, video, or audio content accessible in California, right? So this is not for generally smaller startups. 1 million plus monthly visitors is a mid-sized generative AI company. So if you are running a very small company that's just starting out, this probably won't apply to you. Right? And so the fact is that it applies to your company, even if it's based outside of California, if services are offered to users in California. So let's say, for example, you're based in the UK or somewhere in Europe, and one of your bigger markets is in California, then this type of legislation applies to you and the type of business that you're doing there, even if you are registered elsewhere. And of course, any businesses registered and operating in California also are affected by CAITA. And finally, the licensees of those systems. So not only if you are a generative AI company that does business with users in California, but also if you license out your service, probably via API or other service, you are also legislated by this piece of legislation. So let me go a bit deeper into what that might mean. So let's say you are an audio model provider of some kind. You generate voice cloning, you do generative music, it doesn't actually matter. But then you license out your service to a third party. A common dynamic is for audio specializing companies to license out their services to a video service, for example. So that can create sound effects or be voiceovers for some type of video, right? And so this is where things become a little complex, because as an original audio model provider that licenses out your services to a third party, you are still responsible for upholding the requirements of CAITA, specifically around transparency. So that's something that we'll be diving deeper into a little bit later. But let's look into what those transparency requirements actually are. So there are 4 types of requirements around transparency for CAITA. They sound complex, but we'll be going deeper and deeper into them to understand how to solve them from a technical perspective and what they mean in terms of the law. So the first one is what they call a manifest disclosure. So a disclosure is a way to show where a piece of content came from. It has to do with provenance, authenticity. And the first part of the transparency requirements of CAITA is a manifest disclosure that's audible, right? We're narrowing down into audio here. So that's something that a human being can hear. The second part is a latent disclosure. Namely, a person doesn't have to be able to understand this transparency marking, but a computer or a machine of some kind has to be able to understand it, right? So in traditional watermarks, for example, they're often embedded into the content in a way that a human person won't be able to hear it because it's beyond their frequency range, for example, but this is something that will be readable by a machine. The third part is an AI verification tool, a tool whereby a user directly or via API can verify a content directly with a provider. And finally, the contractual licensee control. So that's going back to the last part we spoke about before this slide, which is how your licensees potentially use your API or service in a later way when they're integrating into their own offerings. So let's look at all these in detail. We'll start, of course, with manifest disclosure. So bear with me here as I read a little bit of legalese, but it's good to understand the encompassing effects of the text on Gen AI providers. So part A, a covered provider shall offer the user the option to include a manifest disclosure in image, video, or audio content, or content that has any combination thereof, right? Combining image and audio, for example, created or altered by the coverage provider Gen AI system that meets all of the following criteria, right? It needs to meet 3 criteria. Number 1, the disclosure identifies the content as AI generated. Okay, that's fairly easy to understand. The disclosure is clear, conspicuous, appropriate for the medium of the content, and understandable to a reasonable person, right? So someone with no kind of knowledge about how AI systems work or how generative AI functions should be able to pick up on this manifest disclosure in some way. And number 3, the disclosure is permanent or extraordinarily difficult to remove to the extent it is technically feasible, right? So a malevolent actor or someone who wants to use the generated content in a way that the original provider didn't intend should have a difficult time in removing this. So we're talking about audio. So this is something that should be audible and follow these 3 criteria. So the solution for this particular part of the law is to include an optional audible watermark. I put in parentheses here beep, but of course you can use something else. If you think about it traditionally, sometimes in videos or radio broadcast, you will have loud beeps or sonic identifiers. You can think of this transparency requirement as something similar. Something that you hear as a person and understand this has been generated by an AI system. It is clear, it is conspicuous, it's appropriate for the medium, and most probably importantly, it's difficult to remove. If you try and remove this full spectrum beep, for example, you will also have to chop out a bunch of the audio. So that way you're filling all of the requirements of the manifest disclosure. So then we're going to move on to the next part. So just again to clarify the difference between a manifest disclosure and a latent disclosure. You can think of it as a manifest disclosure is audible, i.e. real people understand it. A latent disclosure, the machine readable one, is for machines to understand. So let's jump right into what that means in terms of the law. A cover provider shall include a latent disclosure in AI-generated image, video, or audio content, or any content that is any combination thereof. We're seeing a pattern here, created by the cover provider's Gen AI system that meets all of the following criteria. Part 1. To the extent that it is technically feasible and reasonable, the disclosure conveys all of the following information, either directly or through a link to the permanent internet website. A, the name of the cover provider. B, the name and version of the Gen AI system that created or altered the content. C, the time and date of the content's creation or alteration. And D, a unique identifier, right? So this disclosure has to have these pieces of information in a machine-readable format so that this content in the wild can be identified through these key pieces of provenance and authenticity. So the way to do this, the solution is to add a non-audible watermark and encrypted data, especially when it comes to audio. Video and text is something different. So it works because it contains the key metadata, namely the provider name, the system name and version, timestamp, and unique ID that all gets embedded in the metadata and can be read by a machine later on. It is detectable by an AI verification tool. So remember when I spoke about the requirement of an AI verification tool? When it comes to both watermarks and encrypted metadata, this can be read by a bunch of free open source software, or when it comes to MP3 tags, even by iTunes and so forth. So this is easy to read by a machine. It is in combination hard to eliminate. When it comes to encrypted metadata, the whole idea behind the encrypted part is that if someone makes an adjustment to this metadata for whatever reason, the seal is broken, and this can be identified in the reading section of the content identification. And then a watermark, as we mentioned before, is still hard to eliminate, especially one that you can't hear because you don't actually know where in the audio this watermark could be. So in general, it's hard to eliminate. And finally, this is computationally efficient. There are a lot of different ways of doing latent disclosures in audio, but some of them, for example, neural watermarking, more complicated forms of fingerprinting, require computing power that potentially could be expensive. Not to mention you need to hire the talent to maintain it. So we have talked about the manifest disclosure, the beep, the audible one. We have talked about latent disclosure, a machine-readable identifier that a machine can identify those key pieces of information, the provider name, the generation date, unique identifier, and so on. Then we'll move on to the third part of the transparency requirements, namely the AI verification tool. So a cover provider shall make available an AI detection tool at no cost to the user that meets all of the following criteria. 1, the tool allows the user to assess whether image, video, or audio content, or content that is any combination thereof, was created or altered by the covered provider's Gen AI system. So in practice, this could mean the possibility of uploading a file on a provider's website to verify if, content from the wild, file X came from a certain company or not. And as part of number 2, the tool outputs any system provenance data that is detected in the content. So the tool also, as part 3, does not output any personal provenance data that is detected in the content. Subject to subparagraph B, the tool is publicly accessible. So there's a little bit of leeway in terms of how accessible this AI verification tool should be. Now, we suggest that, as I mentioned before, the solution is a web verification portal plus an AI detection model. What you really want to do when you're complying with this part of CAITA is to make sure that you're as redundant as possible. So what do I mean by I say that? So the AI verification tool, the first part is a free public detection pool, web or via API, that verifies content origin. And as part of CAITA, the tool must collect user feedback to improve over time. So if you're using a web-based service, you can log that and possibly have some direct user feedback from people that are using it so you can improve it over time. The legislation is looking for a constantly improving service. So the way that this would work is step one, on-site review. This detects the latent disclosure that we talked about before. So let's say, for example, there is a web formular or a possibility of just, clicking and uploading a file from your browser on a provider's website. This then reads, is the watermark in there? Is the encrypted metadata in there? Has the seal been tampered or not? If all the information is there, great, it will say, yes, this is from our model. Great, then you can also get which particular version it was and what date and so on as a direct user of this service. If the answer is no, then you have an additional layer of redundancy with the AI detection model. So an AI detection model is an additional model that detects with 98% accuracy if something came from something else, even if this watermark has been successfully removed, if the encrypted metadata has been stripped. So in this way, as a provider, you're really making sure to make provenance of content available to users in the best way possible. So, right, going back to our list, we've talked about the disclosures, we just talked about the verification tool, and finally, the fourth part of the transparency requirements of CAITA has to do with contractual license control. If a covered provider licenses its Gen AI system to a third party, the covered provider shall require by contract that the licensee maintain the system's capability. So let's say we go back to our interesting example. You have to use a contract, a legal way to make sure that they don't then remove this latent disclosure, namely to include a disclosure required by subdivision B. If a covered provider knows that a third-party licensee modified a licensed Gen AI system such that it is no longer capable of including a disclosure required by subdivision B in the content the system creates or alters, the covered provider shall revoke the license within 96 hours of discovering the licensee's action. So, right, you have an obligation that if you discover malpractice of some kind of your licensee behavior, then you can revoke that license. And a third-party licensee shall cease using a licensed Gen AI system after the license for the system has been revoked by the covered provider pursuant to paragraph 2. Right, moving on. So, if the system is licensed, providers must contractually ensure licensees maintain latent disclosure. They cannot remove it by contract. Providers must revoke the license within 96 hours if they find out that modification has been done. So the solution to staying compliant with this particular requirement is to, one, of course, ensure latent disclosures don't get removed by some sort of penalty or contractual obligation, and even better, provide the latent disclosure technology to the licensee themselves. So we'll go back to our original model of the sound effects provider for the video AI suite. So they've licensed out their model to the video people. So as part of that licensee process, they contractually oblige video AI suite, in this case, the licensee, to keep latent disclosure. So if they break the contract or if they remove the latent disclosure, they break the contract. And part 2 is to provide the technology to the video AI suite company to generate latent disclosures themselves. In this particular case, we're talking about audio and video in combination, right? Sometimes codecs use compression in the way they transform different pieces of video, and some of these latent disclosures, if they're not robust enough, may be removed. That's when it can be useful to provide the technology via SDK or API or otherwise to the video AI suite company themselves so they can re-add it in. So Now onto the sexy and fun stuff. Enforcement and penalties. What happens if you are one of these 1 million plus monthly visitor companies that operates in California to Californian users, but you don't comply with the 4 transparency requirements that we talked about? Namely, the fine for non-compliance of CAITA is $5,000 per day, plus licensees face injunctive relief and legal costs. So, that could be the licensees themselves if they continue to use the service or subvert the requirement somehow. They could be looking at very large fines in terms of the injunctive relief from the government, not to mention they would have to pay the legal costs of the lawyers. So there's quite a few reasons not to break this law. Now, how can transparency audio help you with complying with CAITA? Namely, we help with all parts of the CAITA AI Transparency Act. Firstly, it's the manifest disclosure. We can provide an SDK or API option to embed audible audio indicators, beep tone or indicator. This can be customized in a bunch of different ways, but what we're talking about is the audible sound in the audio that a user can insert if they so want to. Then we have the latent disclosure, which is our core technology. We embed robust watermarks and encrypted metadata, providing these key attribution and provenance pieces of information: the provider, the model version, timestamp, and ID. We are a significantly tamper-resistant solution. The watermark itself is hard to remove, fulfilling the extraordinarily difficult standard. This is also part of the legislation. The legislators in California want this to be very, very difficult to remove, to, of course, prevent deep fakes and other maluse of Gen AI content. The detection tool and API, we have the possibility to include technology to parse and verify latent disclosures in unmarked audio via API, direct on site, or SDK directly in the Gen AI pipeline. And finally, the licensing control. A lot of our solutions are open source, and we are more than happy to provide licensee, SDK, and terms embedding watermarks. So a third party that has licensed your solution can also get a specific copy of this software in order to make sure that their AI output is transparent. We are already helping a bunch of customers in the generative AI space with this. It's just Kits AI, Coop Music, Deep Noise, Make It, and so on. They all have different specific needs when it comes to AI generated audio and how it gets used in the end. And the fact of the matter is, AI transparency compliance can be surprisingly easy. You can't afford to fail AI transparency compliance. That's why we have an offer you can't refuse. We are currently offering our Godfather offer with the Marking API SDK, AI transparency certificate, custom compliance advice, AI transparency law updates, such as the one that you're receiving right now, all for free until AI law is enforced. That's the end of the presentation. Thank you so much for coming and listening. If you have any questions, I'd love to hear them.
Yeah, let me just see if my dynamics are okay. Can you hear me all right?
Yeah, absolutely, I can.
So the first question I have is, when I think about the companies that would be in scope for this, it would be all the big AI players, because they're all doing generative video and audio and images. And then down into the niches like Suno and Udio and all the voiceover people, they're probably all folks who would get to the usage threshold. Is that accurate?
Yeah, absolutely. That's what I would think too. So there's still quite a big suite of companies that this affects. So of course, and Google's and Facebook's, and like when it comes to it, like 1 million monthly visitors is kind of in the startup sense okay, but like, you know, there's still probably thousands of companies that cross that threshold based in California, you know. So it could go everything from big VO3 down to Suno and Udio, even Splice in the generative music space. A lot of the different voice companies will be affected by this. So there's quite a large remit for companies that will have to comply with the law. I mean, it's interesting. $5,000 a day is probably not a lot to Google, but it's also, you know, something that you, from a positioning standpoint, want to be avoid paying, not to mention avoid being seen as a sort of unethical AI actor, I would say.
Yeah, I mean, if you're Google, you could say, to your point, that's $2 million a year, you know, and if I just pay that, like, that's peanuts. Right?
That's peanuts.
And you know, it's not in the spirit of the law, but you know, how did Uber start, right? So the thing that so the audible signal piece, though, that part I don't understand, because a lot of these companies are trying to deliver the cleanest audio possible, and I think of the manifest disclosure requirement as being like the multiple party recording disclosure, where, you know, there has to be some kind of constant tone that reminds you that the line is being recorded.
Yeah.
How is that going to work if you're Udio and you're trying to create a music file, or if you're doing a voiceover file that's going to be then pulled into something else, you know, and incorporated in some other way?
Yeah. So the one of the key parts of the manifest disclosure is that it's optional, right? So you just have to have the option of inputting this identifier. So my guess is that 99.99% of users won't add this audible signal, right? But they need to have the option of doing it. That way the companies are compliant, because of course, like, one, the companies don't want their output tainted somehow, and two, my guess is that most users don't want this audible tone in their audio either, but they have to have the option to do it.
Yeah, exactly. Okay, I didn't realize it was so it's optional, but you're forced to actually build a mechanism for it.
Correct. So you have to offer the option, but to the end user. So it's not optional for the company, but it's optional for the end user.
Right, but for the company, you can't just phone it in, so to speak, right? Because people who opt into it presumably will really care about what the experience is, the audible experience is. So, so it does force you to actually do it right.
And it's going to be interesting, like, that could be, as long as it's audible and understandable to a human being, that could be a bunch of things. Maybe it's a hilarious little ringtone, or you know, or like, you know, some kind of like sound signature that you have for companies or so on. So I'm sure there's going to be loads of creative solutions of solving that one.
Yeah, I mean, one of my struggles with all of this is that I'm doing a lot of music writing for sync, and it's not clear to me how to do that when you're producing 15 or 20 cuts of the same music, you know, with different instrumentation. And, you know, sometimes a cut down will be just like a bunch of pads. I don't know if you're familiar with the terminology, but, you know, you can have an alternate ending that's 3 seconds long, and that might get used, you know, in a bunch of different productions. So it has to be treated like a fully functional audio asset, when in fact I think of it as being a sub, you know, just a small component, small ingredient of a larger thing. So I'm sort of struggling to figure out how to apply content provenance to that particular space.
Yeah.
But when going back to the larger issue, it seems to me that the big players would just rely on C2PA for this. It seems to meet the manifest disclosure and validation requirements. Is there stuff that's, and also it doesn't have watermarking, but it advocates for watermarking, from what I understand. Is there something missing from there that will, because that'll cover all the biggies, because they're all doing it, right?
So we're of the opinion that C2PA is not extraordinarily difficult to remove, right? You know, like content provenance as a system is a fantastic initiative, but generally, like if you know just a little bit of computer programming where you can type a prompt into ChatGPT, you can strip that away, right? It's also not like encrypted from a cryptographic perspective, right? So it there are some complications with that as a standard. Also, it's quite data intensive. There's loads of kind of information fields and so on from C2PA that are not specific to transparency, right? It's kind of like tracking different transformations through DAWs and all kinds of information that maybe is not what you want in this kind of transparency identifier. There are some other solutions out there, like Google develops a neural watermark that's looking promising, but kind of our idea at this point is to use as many of these kind of fail-safe mechanisms as possible. So that way, if one doesn't work, you've got the other ones to back you up, kind of the Swiss cheese style of cybersecurity.
I see. All right, cool. Yeah, I think that kind of answers my questions. So
Great.
Thanks for indulging me in that. Appreciate
Yeah,
it.
thank you so much, David. Like, you know, write me on LinkedIn afterwards if you got any other questions. Always, you know, super interested to talk about this subject. It's an exciting space.
All right, I'll look you up and follow you for sure.
Cool, man. Thanks, guys.
Thank you. Take care.
Bye.